Today's presentation is on tech ethics and risk management. And so what is that? We thought this was a really important topic for reasons that, as we can all see, technology is moving at a rapid pace, and so rapid that it's gotten ahead of regulation and the law. And so what you see is that there's regulation and there's case law that's forming after the fact as we learn what some of these consequences are of using technology and some of the unintended consequences. So this is a really very important topic. It's very timely for the world that we live in. We're really delighted to have you. And today's presentation is a collaboration between CareBridge International, which is a data analytics company that forecasts care for medical reserves, for litigation, for medical valuations, even for Medicare compliance. And our collaboration is with the Gavel. The Gavel is a very prestigious group of attorneys nationwide. They're highly vetted and they are the best in their field. And with us today, we'll get started with an introduction. I have with me Valerie Edwards, John Balatis, and Amy Hotard. And they are going to take a minute here to introduce themselves and their firms, make a note of it. Again, these are excellent firms. You never know, you might have a question they can answer for you. Valerie?
Sure. Thanks, Deborah, and thank you for hosting this webinar along with the Gavel. I'm Valerie Edwards. I'm a senior partner with the firm of Lux Santinello, Petrillo, Cohen, and Peterfriend. We are a full-service Florida firm with offices all over the state. My practice involves a lot of construction defect, accident, contract litigation. I'm a Florida Bar Board certified specialist in construction law. And I also practice employment practices, liability, premises and products liability, and insurance coverage. And I'm happy to be here and to present with John and Amy.
Thank you, Valerie.
Hello, everyone. I'm John Balatis. Thanks, Deborah, and welcome to everyone. I am a partner with the law firm of Jennings, Strauss & Salmon in Phoenix, and we are also a full-service law firm. We service clients throughout the state of Arizona. We also have a DC office, and I'm also barred in Colorado. I am a management side labor and employment practitioner. I chair the firm's labor and employment department. I've been doing this work in this particular area for the past 35 years. And I'm happy to be part of the panel today.
Thank you, John.
Good afternoon, everybody. Amy Hotard. I'm from New Orleans, Louisiana, and I am from Sally Height, Mercer, and Resor. We have one office in New Orleans, but we do service the whole state. I've been practicing personally since 2008. I'm a partner at the firm, and I concentrate on litigation practice, primarily insurance defense with trucking and auto liability claims, in addition to workers' compensation. Of course, my firm also practices in other areas, including maritime, construction liability defense, and coverage issues. So we too kind of are a full service outfit, a medium-sized firm for our city, but a very busy firm with great employees, and I love working here. And I look forward to doing this presentation today.
Thank you. Thank you so much, everyone. And to our audience, as you can see, these are some very experienced attorneys on the panel that have real world experience. And let's get started. This presentation is recorded. There is as part of the requirement for CEUs, there are poll questions. We will let you know when we put the poll up, which will be momentarily. That is a requirement for CEU that you answer all 3 questions. So very important that you do so. We'll try and highlight again where those questions are. So let's get started. If you have any questions moving forward, just enter that question in the chat. We have Ken standing by to keep us on our toes and answer those questions. And we'll be really Again, this is about you and meeting your needs and answering your questions and maybe giving you some things you've never thought about before. So what are the things that we're going to cover today? Well, we're going to talk about what are the 3 primary risks of AI. We all know there's risks. We read it in the newspaper. We're learning more about it as we become more familiar about what it is, that there are risks involved as well as the benefits. And then we want to discuss the need to integrate ethics and risk management as part of a governance framework within your organization, or if you're an attorney and you're working with companies, it's really important now more than ever that ethics are integrated with risk management with respect to technology practices, and that you have some framework for that in your organization. And then you want to walk away today with identifying at least one ethical principle to apply to technology risk management to a best practice that you might consider for your own organization. And then name a risk measure that can expose unethical constructs, very important, and identify a risk strategy that can be used to promote ethics in technology. So moving forward, a little background, why this topic? Why is this important? Well, technology is a big topic. Technology ethics is now a separate construct around ethics. There are different fields of ethics, healthcare ethics, all kinds of domains of ethics, but there is a new domain just in the last 3 to 5 years around technology, and it's called TEThics or tech ethics. You may hear it either way, tech ethics or TEThics, becoming a bigger and bigger body of knowledge as we learn and grow. Again, since the technology is ahead of the regulation and some of our thinking around protections and risk management. So ethics are principles that can be used to govern your technology. And there are factors like risk management and individual rights, considering individual rights. And again, I love this quote, most IT departments aren't thinking about a formal risk management strategy. And if they are, it's back of the napkin planning. And so how many of you actually feel that way? You kind of deal with it as it comes up. We're not ahead of it. We're not thinking about it like we should around risk management. So to our poll questions, let me go ahead and launch that. AI will drive organizational change and ask more of top leaders. If you're an executive or you're in a role with oversight for risk management and governance, this is becoming more and more an important issue. AI will place new demands on CIOs and CTOs, Chief Technology Officers, and AI will require an increased focus on risk management and ethics. I have a question here. Let's see, can you all see the poll questions? Can we see the poll questions? Okay, very good. One question is up. I see a question. Okay, next slide. In debates about artificial intelligence, you all can read this. But again, AI is very, very powerful, as you're starting to see. What is it? Artificial intelligence. It's where we're pulling data points together and we're able to learn through a massive amount of data and predict things. And it's really the underpinnings of electric cars, electric vehicles, a lot of the technology that we're seeing today that's being used, that's new in InsurTech, for underwriting, for claims, for customer service, for even law. AI is into the legal space now, where predictions can be made about lawyers and win rates and so on. Its possibilities are endless, and it's only going to continue to grow. So how is AI reshaping culture, policy, and process? The AI world doesn't need more restrictive regulations. This is according to a Forbes quote just this year. We just need more fair, ethical systems, full transparency, open democratization, and choices to drive the best innovation and impact in the market economy. And I think some of the examples today that our attorneys are going to talk about will drive this home. So let's get started. We're going to discuss the need to integrate ethics with risk management for these key reasons. Really importantly, if you have a CIO or a CTO in your organization, these are the reasons to have this conversation with them. You need to have a more reflection in the design process. When you actually are designing technology or you're working with a technology, how was that designed and what moral parameters and what steps did they go through to ensure that there is an ethical process in the development of the software or the tools? And what was the stakeholder analysis when that was built? You have to think about unintended consequences, what could occur that we hadn't thought about before. What are some of the social issues that we need to be thinking about? And having trust, what is the reliability, who's taking responsibility, and what is the legitimacy of that product? We all know that these things are only as good as the data that goes into them and the ethics. So I'm going to hand this over now to John. He's got an excellent story. John?
Thanks, Deborah. Hi again, everybody. I'm going to speak today about Amazon as a case study to talk about AI and how it's being used to monitor and measure employees. I'm going to venture a guess and say that most of you have an Alexa device either in your home or your vehicle. We've got one in the kitchen. We ask Alexa all sorts of stuff all the time. I always assumed that when you ask Alexa a question, that question was used momentarily to generate an answer, and then it disappeared in the ether. I never assumed that it was stored anywhere because that really didn't make a lot of sense to me. In reality, if you use Alexa, every time you ask a question, Amazon stores your voice print and records your question. So somewhere in Amazon, there is a database of all the questions you've ever asked Alexa. It exists. And Amazon periodically analyzes that data for marketing to determine what your preferences are, maybe to sell it to third parties to use it for the same purpose. And what's interesting about it for today's purposes is that this is Amazon's business model. Amazon has become the empire it is because its business model relies on the gathering and use or exploitation of information. It's part of Amazon's culture. That's how Amazon has succeeded the way it has. And so it's not that surprising because it's an aspect of company culture that this perspective has spilled over into the way Amazon monitors its workers and measures their performance. Earlier this year, Amazon Prime drivers learned that all of their trucks were going to be equipped with biometric feedback devices. Depending on the configuration of the vehicle, this can involve either 1, 2, or 3, or even 4 cameras and other devices in the vehicle. And the devices monitor the driver at all times. And so if a driver is distracted, if a driver yawns, if the driver fiddles with the radio, all of that video is getting recorded. And if too many of those events are viewed by the system as not work related, not efficient, that video series is then downloaded and sent to that driver's supervisor for disciplinary purposes. The problem with it is, from an AI perspective, that the devices are measuring benign events that shouldn't be counted against the workers at all. I read an article just yesterday, because this is still in the news even months after this was first announced. Drivers are really put out by the fact that if they look at a mirror, one of their side mirrors, or they have to swerve to avoid another vehicle, the biometric devices are recording those events as improper performance events for disciplinary purposes. All right. In 2019, Amazon took a somewhat similar approach with its fulfillment center workers. The fulfillment center workers' scan guns are used to measure what the worker is doing throughout the course of a shift. And each worker is allowed 18 minutes of what's called time off task during a shift. So if you stop to chat for a minute with a coworker, get a drink of water from a water fountain, the scan gun is able to determine that the employee is not actually deliberately working. And then those momentary events are counted against that worker's 18 minutes of time off task in that shift. If too many shifts involve 18 minutes plus of time off task, these workers will receive disciplinary notices automatically. And in some cases, they're separated without even a human being getting involved, because the system itself, the AI system itself, handles the HR aspect of this as reported through the scan gun. And to take it to its logical extreme, Amazon is now developing a wristband that will be used in fulfillment centers, which actually will go further than the scan gun. It will actually monitor the worker's movements in real time. And if the system believes that the worker is acting inefficiently or is doing something wrong, the wristband then will vibrate or otherwise communicate with the worker and redirect them. Next slide, please. So what does all this mean for our purposes today? Obviously, as a business, you have the right, and you should to an extent, utilize technology, worker monitoring and measuring, to optimize efficiency and increase your profits. That's every business's right, and frankly, it's every business's responsibility, especially those businesses that have shareholders. But in Amazon's case, based on the feedback that we see in the media from the workforce, the widespread dissatisfaction among workers about the way in which Amazon is utilizing AI technology to monitor and measure makes clear that the workforce does not perceive that the company is taking a fair approach to the use of technology in this way. Next slide. So how can a business correct this problem, if you will? How can a business improve the workforce attitude about the way in which it's using AI to monitor and measure? Well, the primary principle I think that is at play here is collaboration. Collaboration is probably the best tool to use in measuring whether a company's use of AI technology is perceived to be fair. And by collaboration, what I mean is encouraging employees to participate in the process of formulating, developing, implementing technology systems so that there's a check and balance in the process. And those employee representatives, if you will, in the process can talk about whether or not what they're seeing is perceived to be too aggressive or invasive in terms of the way productivity is measured and performance is being monitored. This is a concept really that applies in a number of different areas. Securing employee collaboration as a way to get a workforce to buy into a concept or an objective, but it is particularly applicable in terms of AI and the way AI is used by a business to monitor and measure. So Deborah, do we have a poll question here? You're muted.
Thank you. Yes, there is a poll question. Thank you, John. Relevant to this particular slide. So if you've not had an opportunity to take a look at these poll questions, please do so now.
Thanks, Deborah. And when you're ready, we can go to the next slide. There you go. So what can a business do to promote collaboration in the design, development, and implementation of technology so that you don't end up in a situation like Amazon where you have widespread, dissatisfaction among your workers that is then getting promoted significantly in the media, which is not good optics, right? Well, some of these are very intuitive. They're not groundbreaking concepts because, like I said before, these concepts can be used in connection with other objectives or areas, but they're particularly applicable here. One approach is to form a committee or a task force or another dedicated body that includes frontline employee representation, and have that body then be charged with the task of studying, developing, and then proposing technology mechanisms to a board or a management body. And so when that employee representation on that task force or that committee or that body becomes visible to the rest of the workforce, and the work of the task force or the group becomes transparent to the rest of the workforce, that collaboration naturally is going to result in a certain degree of buy-in from the workforce, because the workforce then on the whole will see that it's represented in the process. It has its own members participating in the design and proposing of technology systems. And theoretically anyway, the larger workforce then should become more comfortable with the process and should buy into it. Another approach, which is completely different, would involve the outsourcing of this whole process to a third party, to a vendor, with the thinking being that the workforce would perceive the outsourcing to be a step that management is taking to neutralize the design and development of the technology, meaning it's not the company which is designing and technology or designing the technology anymore. And the company, of course, has the incentive to act badly, to implement measures that are too aggressive, too invasive, whereas the third-party vendor is more neutral and is theoretically taking into account what is reasonable in the market for purposes of monitoring and measuring. That approach, the outsourcing approach, also should generate some buy-in on the part of the larger workforce. Another approach might involve, and we do this on a number of different levels with respect to different aspects of firm management, participating in a trade industry group or consortium that brings together representatives from other companies that are maybe not necessarily your competitors or your direct peers, but at least are members of your industry. And you get together and you talk about what each other is doing as a business in terms of designing and implementing AI in the workplace to monitor and measure. And that think tank process, if you will, also will communicate to the workforce that you are taking steps to make sure that you, as those individuals' employer, is at least within the parameters of what's reasonable, because you're consulting with your peers in the industry to figure that out. You know, when you go to hire a person, you go to the market to see what to pay them, not just because you don't want to overpay them. You want to treat them fairly. You want to treat the worker that you're hiring fairly based on what the market is telling you. Same thing is true when it comes to AI. Let your workforce know that you are trying to do what's fair in the marketplace in terms of monitoring and measuring them. And so that, Deborah, is really my part of this. It's less of a legal presentation and more of a practical one based on a real life story.
Yes, no, excellent.
All right, Deborah, I'm going to pick up from where
Okay.
John left off. The first thing I'm going to say, though, is that after his presentation, I think I'm going to go home and throw all my Alexas in the trash. That
Yes.
said, I'm going to kind of
Yes.
shift this a little bit, right? John talked about an employment setting, and he talked about employees and businesses and generally monitoring your workforce. I am shifting this to a risk management perspective. So we're going to kind of go that route and leave this employment setting. But oddly enough, the first case that I'm talking about does talk about an employment setting. So let me set that up a little bit, though. There's been an explosion of social media with the advancement of technology, obviously with the internet, and social media has grown. And now things are sold on TikTok, bought on TikTok, or in people's Facebooks. People are starting businesses. People are becoming social influencers as a job, right? So social media is starting to become very, very prevalent. And from a risk management point of view, it becomes useful to us. As I said earlier, I do a lot of trucking and auto liability defense and workers' comp claims. So my risk managers are always looking to social media outlets to find out information about these claimants or plaintiffs. And I'm doing the same thing. I think most attorneys do use social media in some form or fashion. And I think most risk managers do the same thing. So again, my purpose is to focus on social media. And with respect to risk managers, I want to talk to you about the ethical obligations and concerns that we might have with the use and harvesting of social media. And that is why this case is relevant. Believe it or not, there's not a ton of cases on risk managers harvesting or using social media. But what we need to do is look at other cases and apply those same principles to risk managers, to the acquisition of social media for the use in litigation, for the use in negotiation. So let's talk about this first case. This is the Ealing versus Monmouth case. And the reason that I wanted to point out this particular case is because it's an example of a concern that any risk manager or business might have with respect to the use or the decision-making based on social media. And again, I said I've kind of circled back to employment because this is essentially an employment case. It's kind of a tale as old as time. You have a co-employee who either doesn't like or has some sort of issue with another employee that sees a post on social media, takes it to the employer raises it as a concern. Now, admittedly, this employee that the social media post was made by was not the best employee. She had some other strikes on her record, but she was subject to disciplinary action because of her social media post. What made this case and makes this case somewhat important here is the tactic and way she went about claiming that her privacy and her rights were violated. In this case, the Federal Stored Communications Act, so the SCA, that's the Stored Communication Act, was used and was alleged as violated. And the court actually did say that Facebook, which is the social media site at issue here, is under the SCA, and I'll explain why. So the Federal Stored Communications Act concerns things that are put in an electronic communication, which is what Facebook was considered to be. And also that electronic communication was transmitted, which it's transmitted over the social media site. Again, the court says, hey, this falls under the SCA. And then it's in an electronic storage. So Facebook stores your posts, it archives it. So again, it still kind of falls under this definition of this federal act that nobody's going to be thinking about when they are obtaining or harvesting social media information. And in this case, what becomes important to risk managers is an authorization for use of or for viewing this particular person's social media site. So let me explain that a little bit more. In this case, the individual who had posted the inflammatory comments on social media had a private profile. And because it was private and not public, that's what made it fall under the SCA. Because of all these other tick marks that were made in this statute, the last tick mark was, of course, hey, was this private? Was it meant to be private? Was it meant to be shared publicly? And in this case, it was not meant to be shared publicly. But alas, that co-employee was a friend of hers, right? So he had access to the Facebook information. The employer didn't go seek the information unlawfully, didn't persuade her, didn't coerce her, didn't force her to turn over her social media. Instead, this co-employee did it for her and got her in trouble. So why is this important to us? It's important to us and important to risk managers because it says, hey, it falls under this statute that nobody's thinking of, this act, I should say, and it can result in litigation, which has already been determined in the New Jersey District Court to be applicable to Facebook. But what's the exception? How can we get the information without getting in trouble and getting our business in trouble as risk managers? Well, we harvest the information in the proper way. In this case, the proper way was that this person was an authorized user, right? So looking at kind of the notes from this, when there is an authorized user, right, and somebody that's able to access this profile that would otherwise be deemed private, it's no longer private. So we can get into that, just like we can get into a public profile. And so that kind of leads to my very first point in harvesting. When we harvest social media information, it has to be done ethically. And next slide, please. In doing that ethically, okay, and I'm not going to start on this next slide. I just wanted to kind of move along. I wanted to take the focus from that. You have to ask yourself, what are the best ways, or what are the ways that I'm able to access social media? The first and easiest way is, of course, a public posting, whether that's TikTok or Facebook or a video that you can obtain. That's one way that you can protect your company and business from cases like E-Link, okay? Another thing to consider is if you're friends. Now, don't go friend this person after they've been involved in litigation, all right? Don't go friend this person once you've seen a letter of rep, and we're going to touch on that in a minute. But if you're already their friend, like this person in E-Link, you've already got access to the information. You're an authorized user. That's more unlikely. What I see more often is a public posting. So again, those are green lights. We got to think about the red lights. The red lights, if you are to friend request them, is that a red light? I would say yes. I would say it's particularly a red light if you do so under false pretenses. Don't go create a fake profile to go friend someone and see their Facebook post, because you're going to end up violating an act. If not the SCA, you're going to be in trouble somewhere. Or even at the least worrisome result, you're going to end up having the evidence that you've obtained excluded. And that's not helping anybody. And so you've just wasted a bunch of time. Now, another thing you can't do, obviously, as mentioned in E-Link, is you can't use coercion. And so you can't tell them you have to give me this information, or you have to give me your Facebook post, because again, they have an expectation of privacy under this act. Now, moving to this next slide, it brings me to my next point, which first it is harvest ethically, and then also use ethically. All right. It's should go without saying that, and I'm sorry, go back to that last slide. Thank you. It should go without saying that you don't want to post about your claims or your cases. And that's kind of a twofold step. And I'll tell you why. You don't want to post about a claim or a case on your own social media. All right. And you don't want to post somebody else's social media to your own social media. And what I mean by that is, let's say you've got a good photograph of somebody doing something they say they can't do, and you put it on your Facebook page and say, isn't this ridiculous? That's a really good way to lose your licensing. Don't do that. And in fact, I'm going to use kind of parallels here between what attorneys are seeing and how that can also apply to risk managers. Because if an attorney is going to lose their licensing over some posting that they've done, that can certainly happen to a risk manager. So let's kind of go to this case right here, this In re Perricone. This is actually a Louisiana case. And I will take you through that. They had a U.S. attorney in the Eastern District Court of Louisiana who was obviously he's a prosecutor, all right. He was going to forums and chat rooms and what have you anonymously and posting information about the cases he was prosecuting. Now, of course, it was anonymous. And the Supreme Court looked at this case and reprimanded this man. Not only did they reprimand him, they disbarred him. He lost his license. So a federal prosecutor lost his license for misusing social media. That's a big red flag for anyone that is concerned about whether they're doing something ethically or not. And even though the court found that he didn't have any intent, in other words, he wasn't intentionally trying to harm the cases he was involved in, he was trying to heighten public condemnation for an individual through the use of his posts, even if they were anonymous. And so that's what ended up in the result that you see in this particular slide, and this attorney being disbarred. And there's actually a phrase in the case that I kind of like, and there's a takeaway from that. And it's kind of, don't make untested allegations in press instead of the courtroom. And Valerie's going to talk to you a little bit about some of these uses in litigation, but I want to make sure that the risk managers understand that just because I'm talking about an attorney here doesn't mean it can't be used, or these ethical concerns don't apply to risk managers, because they do. It's an across the board issue that's addressed by acts, that's addressed by disbarments, that's addressed by ethical rules. And really, again, I want to kind of harp on, don't post about it, and make sure when you get it from a source that is either public or that is accessible to you with permission. All right. So now going to that next slide. And again, there'll be some overlap here between Valerie and myself because these model rules are applicable not only to attorneys, but attorneys' agents. Now, looking at model rule 4.2, we are prohibited, okay, attorneys and attorney agents are prohibited from requesting a connection to a represented party through social media networks. Now, I'd mentioned a little bit earlier, if you get that letter of rep, don't go try to friend somebody on Facebook. Don't send them a message. Don't use social media in a way that's going to get you in trouble. You can still go look at their public page if they have one, and you could still take screenshots, and you can still pull those videos that are going to help your case, but don't take any actions, because if you're requesting a friend request of someone that's represented, you're kind of communicating with someone who's represented by counsel, even if it's not a direct message. And of course, a direct message is a definite no-no. So attorneys, and again, this addresses attorneys, and Valerie will take that over, but it is applicable to us too, because it's an ethical concern and obligation. And when I say us, I mean risk managers. Now, ABA Model Rule 8.4, an attorney violates ethical obligations when using deceptive tactics to gain access to a private account. This kind of goes hand in hand with E-Ling, which is basically saying, don't try to get social media information through the wrong avenues. Try to get things that are public, try to get things that you already had access to or you had permission to access. You can't use coercion. You cannot, put the claimant or the plaintiff in a situation where they feel like they have to give you this information, because it is private and there are privacy concerns. So one of the things that's on here too is they talk about how an attorney may request permission to review an unrepresented person's private social media information. We can request it. Unlikely, and most of the time, by the time it gets to litigation, there's another attorney involved. But again, Valerie will probably go into this a little bit more. My purpose and my points, again, are to just say, make sure you harvest it the right way. And before I turn this over to Valerie, I also want to make sure that risk managers are aware of how to harvest the information. It's great when I get information from my adjusters, for example, a video that was taken off of Facebook or a screenshot of a page, but please make sure you get the link. Make sure that all of that is captured. You can't just send me a video. It's not dated. It's not, it doesn't have all of the requisite information. So a lot of times you can use vendors that will obtain the appropriate HTML information, the metadata that you're going to need to prove when things were posted. That's very helpful when it comes to the litigation portion. And it also helps me to prove when these things were posted, because let's say they are in the claim, the risk manager has all this great social media stuff. They go to their attorney, they hire an attorney, and attorney says, hey, make sure you make your Facebook profile private. All that information goes away. And I don't have the metadata. I don't have the information I need to ensure that this post is proven to be what I say it is. In other words, a post that was made on X date at X time after this accident occurred, because who's to say she's not going to get on the stand and say, I didn't post that then, or this picture was taken 3 years ago. It's very important that we do these things the right way the first time. So I do hope that going forward, everybody takes into consideration that although social media is a new facet for obtaining information, that we use that properly, we obtain the information the ways that we should, and we don't try to get into any loopholes or try to unethically harvest or distribute the information we receive. So I'm going to turn this over to Valerie, and thank you.
Very
Thanks,
helpful.
Amy. Thank you. So, yeah, the ABA model rules do apply to attorneys. Most states also have ethical codes and rules that are applicable to insurance adjusters. And so they have similar provisions to Rule 4.2, which prohibits contact with parties who are represented by an attorney. The ABA rule specifically requires that if you're going to make contact with such person, you need the lawyer's consent to do so. And there are also ethical rules applicable to adjusters that prohibit deceptive tactics in investigating a claim, which are similar to the Rule 8.4, which is related to attorney misconduct and maintaining the integrity of the profession. And it has a number of actions and conduct that are prohibited under the ABA code. The ethical rules that are applicable to adjusters have similar type of rules. And that there is a 2-hour ethics course for adjusters that goes into a lot of detail on that. So yeah, this is a super important topic, and something that everyone needs to be aware of. In Florida, social media account information is discoverable. And that's based on a case out of the 4th District Court of Appeals related to a Broward County, Florida case. It was a slip and fall case against Target. The Target attorney reviewed this woman's Facebook profile before her deposition and saw 1,285 photos. Then after her deposition, he saw 1,249 photos. And so a discovery request was served to have access to her Facebook profile. So going through the right channels here, serving discovery. Plaintiff objected, mainly asserting her privacy interest in her Facebook account. And the court found that because she had put her physical condition at issue in the litigation, the Facebook photos were relevant, and that relevance outweighed her privacy interests. And so the court held that access to her Facebook profile was appropriate. And with a lot of this social media discovery, it does have to be narrowly tailored in terms of time and what's being sought as part of the discovery. And so with some limitations, the access was granted. So that's a state case. On the federal court level, the Anderson v. City of Fort Pierce case also allowed discovery of social media account information. And that one, the underlying case was a sexual harassment, discrimination, and retaliation case made against the City of Fort Pierce Police Department. And access to the plaintiff's social media account was granted, also based on the whole relevance outweighing the privacy interest in the information within the account. And so it's important to remember, though, that there are multiple sources of social media information that can be subject to discovery, not only Facebook, but YouTube, TikTok, Instagram. On cases where there's a claim of bodily injury, fitness trackers are discoverable. Blog accounts can be discoverable. And so there's a wide variety of social media information that should be included in a discovery request if one is appropriate. Next slide, please. And so it's important to remember that in terms of your discovery request, that you are able to show that the information is relevant to a matter at issue and will lead to the discovery of admissible evidence. And on the other side, if you're trying to block that discovery, you have to be able to show that there's some sort of inaccuracy, or that the information is unreliable, or seek the limitations on the discovery in terms of the time period covered by the discovery request and the scope of information sought in the request. Again, ABA Rule 4.2 basically prohibits contact directly with the party who is already represented by an attorney. So you have to be careful in terms of how you request that discovery. And then 8.4 is the rule that prohibits use of deceptive tactics to gain access to a private account. Next slide.
So this is a poll question, everyone. This is your third and final poll question. I do see in the chat, there's a lot of concern about the poll questions not being answered. I can tell you on my side, I can see that the first and second questions have been answered in their entirety by everyone who's attended. It appears as though that's the case, but nevertheless, the poll is up again for the third and final question. I think, as you've seen Ken communicate with you, that if for whatever reason you are having challenges answering the poll questions, do answer it in the chat. Put your answer in the chat, and we'll reconcile those answers at the end afterwards to make sure that you get credit. So I'm not sure why we're having some trouble with the poll questions, but we are. And so we'll go ahead and work through that by having you answer. If you're not able to answer the question itself in the poll, go ahead and put your answer in the chat. We'll reconcile all of it after the presentation. Thank you for that.
Thanks, Deborah. Okay.
Next slide, Valerie.
Yes, please. So 2 more ethical rules. ABA Model Rule 3.4 and Florida's counterpart, which is based on the ABA rule, are rules against obstructing another party's access to evidence and prohibiting the unlawful alteration, destruction, or concealing documents or materials having potential evidentiary value. And where this comes in to the whole AI social media spectrum is based on the fact that some social media platforms have an auto delete of information after it's been removed or modified by the user. So it's important if you're going to be seeking discovery information or social media information, it's important on the defense side, when you are making your appearance and setting up your file and serving your answer and your discovery, that you also, serve a request for preservation of electronically stored information, so that plaintiff's counsel or the claimant is aware of the need to preserve that information. And on the defense side, on the company side, it's important to have practices in place that, litigation hold type practices, as well as just basic access and deletion policies in place, so that there is some sort of control maintained from a risk management perspective and a company perspective, to avoid some of these potential pitfalls in terms of a claim that you destroyed data or modified a social media account, or that your client destroyed data or modified a social media account improperly. So that is the end of mine.
Okay.
So I think we're
Thank you,
ready.
Valerie. Thank you, panelists. Really appreciate that. I think what I want to conclude with is that, hoping for the best is not a risk management strategy, right? Risk management has a process. There is a specific process. And part of that process is being able to get in front of some of the risks. If you have risks, using your bonefish diagrams and various things to try to identify where some of those risks are. But also, one of the things that we're seeing is that you've heard of IoT, the Internet of Things. And I want to pull all this together because what is IoT? I'm going to start from the very beginning of this presentation when I think it was Amy and John were talking about Alexa. So here's the future of IoT. Internet of Things means now that we have all these data points that exist in Alexa about you as a user, on your watch, right? Your exercise watch, we've got all the information about what was happening, activities, when your heart rate was up and so forth. And then take it the next level. Your activities that are posted, date and time stamped on social media platforms, the telematics, all the cameras and the measures that exist in your automobile, the cameras that are out on the road. Eventually, all these data points can be aggregated and we can piece together your entire day, my entire day, what I was doing at every minute of the day, where I went shopping, how much I spent, how much time I was in my car, when I had to swerve, how fast I was going, whether I was exceeding the speed limit or not. All of my actions, everything that I'm doing in the world of IoT will eventually integrate these data points into a complete picture. And that's where these questions, it becomes very, difficult because who owns the data? Who owns that data? And we've learned some of that today. We talked about that, about an attorney can have it the opportunity to hold. You can ask for those pieces of information to be held. So, what belongs to me, or who does that data belong to? Just like today in an automobile, if you rent a car and it says, hey, sync up your phone to the car, all of the information in your iPhone, I mean, all of it is downloaded to the automobile. Is that your information? Does that data belong to you? Depending on the state you're in, maybe not. And as the laws and regulations evolve, maybe not. And so it creates a lot of legal challenges when you're trying to capture these pieces of information for your claim or in your employment, in your company, the things that you're trying to measure. There really are, it's a real tug of war about who owns the data and how that impacts the individual and what are some of the ethical ramifications. So really important topic. I hope that you enjoyed this. To wrap things up here, are there any final questions that folks might have? I do not see any questions. If there are any questions, we'll pass those along to the appropriate attorney here who can get an answer to you quickly. And we do appreciate, time is up. We appreciate your participation today. We hope you found this information to be thought-provoking as you try to work through your own risk management and technology ethics, governance, ways to think about it. Again, this is an area we're all learning. We're learning as we go along. There's going to be plenty of work for the law firms for a long time, you know, as we move into this new era of technology. So there's so much we don't know. But what we do know is there's already a precedence that's been established. The precedence that has been established is that we as consumers are willing to post public information and have information out there and allow that to be monetized for the benefit that we get from these social platforms. And so that it's very gray and it's very fuzzy. But thank you all. Time is up. I thank you again for your time today, for joining us, and we hope this was a helpful presentation. If you'd like more information about the Gavel, please visit the Gavel at www.thegavel.net. And we do have information here on all of each of our attorneys who presented today. As you've heard, they are they have practices that can address almost any problem that you might have. So we encourage you to get to know them. And we hope, again, that this was useful information. Thank you for joining us, everyone. Enjoy the rest of your day.
Thank you.
Thank
Thanks,
you.
Deborah.
Thank you,
Thanks,
panelists.
everyone.
Thank you.